Hello, and welcome to part 5 in a series on compensatory education in the post-pandemic world. We're going to talk today about dispute resolution ideas. We've had parts 1 through 4 that have been recorded over the last 6 or 7 months, and this is the final part in the series. It's presented through Stone Soup Group and as a parent learning circle, specifically for parents, guardians, and other surrogate decision makers for special education. And it was provided through funding from the Alaska Mental Health Trust Authority. I'm Ann Applegate, and I'm an attorney and a consultant. My background is in special education and also in providing services and education for advocacy for people who experience developmental disabilities, particularly in Alaska. What we're going to do today is talk about some specifics around dispute resolution. We have a lot of frequently asked questions from parents through the last several years about what happens now that we've returned to school and the pandemic crisis is over. What do we do about the periods of time during restrictions for the pandemic in which students were not provided fully their education as described in their IEPs? So we have a lot of those, and I think those are a good way to address a lot of kind of different circumstances in which conflict would arise between parents and schools or school districts. I'm going to give a quick look at laws that protect students with disability, just so that you know their names and know when they come into play. And then we have some ideas for resolving disagreements and disputes. I'd like to provide you with some online resources for forms, sample letters, sample requests, and also the information about how to get more help for your claims or your disputes, and also about the law and rights. One of the questions that comes up a lot, and we've talked about comp ed in a lot of contexts before this part 5 today, but we never reached really who decides whether comp ed is due. And I think that that's an important thing that parents need to know. The first line of deciding whether comp ed is due is that IEP team. So it's an important thing to request a meeting specifically to address what education was missing or not provided or not fully implemented during the times when students had interrupted access to their education. And again, that IEP team, I've said it over and over again, a group of people knowledgeable about the student, including family members, the related service specialists, that's physical therapists, speech language pathologists, and occupational therapists, other people that are specializing in those areas, teachers, counselors, psychologists, school administrators, social workers, doctors, and school nurses. And that also includes anyone with special knowledge of the child, anyone that the parent wants to include in that meeting. They are using the IEP and reports from school experts, any independent educational experts that the parents have sought out and gotten information from, the progress notes, those quarterly progress notes, as well as schoolwork samples, observations that are done, formal observations that have a strategy and basically a chart for measuring what kinds of things are being seen and when, and evaluations or assessments. Those are the basis for the IEP team to decide whether comp ed is due. The district have to give parents proper written notice of an IEP team decision. So that's the next step. If the IEP team comes together and uses these documents and the observations from experts and parent contribution, and decides that something is or isn't giving rise to a comp ed claim or a need for comp ed, then the district has to write that out. We talked about that in a prior slide in a previous part of the session. Now, if parents don't agree with that prior written notice about the IEP team decision, they can appeal the decision. They can also request mediation. They can file for a due process hearing or submit a state complaint seeking an investigation of the facts of the matter, the circumstances around what they see as a gap, a material gap in special education provision, implementation of that IEP. A parent can also submit a claim to the U.S. Department of Education's Office of Civil Rights, and we'll talk about that a little bit later. Now, if a parent makes a request to have the team meet to talk about comp ed and to look back and see what wasn't provided or what was provided but wasn't consistent with what the IEP said should happen, and the district doesn't hold the IEP meeting on the need for comp ed, then the parent can ask the district in writing for the IEP meeting to discuss their child's needs for comp ed and request for a facilitator. I think that's a good first start. Now, here was another question that came up. How long do parents have to file due process petitions seeking compensatory education? What we heard is that people were being told that the 2 years were up and they didn't have any more time to request comp ed. And it is true that in 2004, the amendments to the IDEA enacted a statute of limitations of 2 years. But the 2 years started in the law. The starting gun for those 2 years was when, quote, the parents knew or should have known about the alleged violation. Now, what I want to say, and I've said it earlier, and I'm saying it again, is that this is the kind of thing that lawyers argue about and judges have to make decisions about. What was the time period when someone knew or should have known about an alleged violation, and whether or not there is any attempt to maybe mislead a parent about the severity of a need or about the amount of services that were actually provided, whether the progress notes were accurate and showed the real amount of time that a specialist was there, or didn't include the fact that something that was supposed to be a direct one-to-one service was instead provided in a small group setting. So all of those things are part of whether somebody should have known that their child wasn't getting the full implementation of the IEP. So don't be put off by a calendar that shows you that it's been 2 years since the first day that the student didn't get whatever service was promised in that IEP. It's really going to vary depending on the facts specific, not just to each parent, but to each circumstance. So I've underlined this again. Don't let the fear of being time limited stop you. It's an argument for lawyers to make and for lawyers to defend against, and it's been grounds for appealing and reversing the dismissals of parents' claims often. So don't let it stop you. That's not one of those things that if you hear from a school team member or from an administrator, just think to yourself, they probably don't understand how complicated it is, and you're not going to stop there. Now, here's a question that comes up a lot. Again, a lot of these do. Does a student need to lose skills or regress for them to be entitled to comp ed? And we talked about this when we talked about extended school year standard, which is where this comes from. it's kind of related. And so it's understandable that people would think that this is part of comp ed as well. But that is really about whether or not a student should have extended school year services during a period of time when they might lose skills that they couldn't recoup in a reasonable amount of time. That's the standard for extended school year services. For comp ed, I want to be a firm here and say nope. Regression and the failure to recoup lost skills within a reasonable time is not the standard for comp ed. And the aim of comp ed is to place the student in the same position they would have been in, but for the district's violations of the IDEA, the failure to provide that free, appropriate public education called FAPE. A court that recently decided this issue in the context of a COVID deprivation of education said specifically that linking comp ed to whether the student regresses and doesn't recoup skills within a reasonable time could never put them in the place that they would be in, but for the district's violation of the IDEA. The court reasoned that since the proof of harm is not required, it follows that a material deviation, that means something that had an impact, so significant kinds of deprivation of education from the IEP is harmful automatically under the IDEA. If it's material to their getting the skills, achieving the goals that are in their IEP, then it doesn't matter whether they lost skills because all of the skills are building blocks to the next skill. And it didn't matter that the student had graduated from high school in 3 years in this particular case. The school district tried to say that because she graduated early, there wasn't any harm to her. And the court again said that that's irrelevant to determining whether she was entitled to comp ed for the failure to implement her IEP, and holding otherwise would take out the heart of the need for an IEP. It's about building on skills, and that student would miss the opportunity to grow even more. Another case said that the student was getting a passing grade, and the school district said it didn't impact the student because the student was able to pass the class, and that was what was an equal access to education. And in that case, the court gave an example, and I thought it was really worth talking about, that you imagine a student who had the benefit of their free appropriate public education, and that they would have learned, say, to add in 1 month, and then multiply in month 2, and then divide in month 3. And if the school system denies FAPE in month 2 in a way that prevents her from learning to multiply, but also causes her to lose the ability to add, a proper compensatory education award would be to both reteach addition and multiplication. It's about the consequence of missing the opportunity to learn. Honestly, what they say is that at most all it would do if we relied on losing skills is to return them to where they were before the school district stopped providing what they were supposed to provide under the IEP. And they don't need to suffer measurable educational harm if the district fails to fully implement their IEP. The idea here is that if a student loses skills, that's just an additional reason why a student may be entitled to compensatory education. And if they lose skills they previously had, then the Comp Ed Award would not only have to provide for the reteaching of the lost skills, but also compensate for the new skills that weren't gained, that would have been built upon that block of the foundation. We've scooted around this issue a couple of times, and it's because there's a lot of variation in how the compensatory education amount is determined among different circuits, the federal appeals court circuits in the country. And so I'm going to talk about both of them because honestly, in our circuit, the Ninth Circuit, we do a kind of a little of both. And it's a broader kind of whole look at the lost opportunity for learning. But courts have used two approaches primarily to determine how much comp ed to award. Um, Lots of them use the quantitative approach. It's sometimes referred to as the one-to-one ratio approach. And an example would be I lost an hour of speech, and so I should get an hour to replace that lost hour of speech services. The other is a qualitative approach, and that is one that asks some questions. You know, how was your child doing before the school buildings closed or before they had to reduce the number of minutes of a particular service, or the place in which they provided those services meant that the kid didn't really get the benefit of that education. And what happened with the services during the pandemic? Were they provided by a qualified specialist? Was the aide uh, appropriately trained? If not, then that probably wasn't considered a real minute of service delivery. What services are needed to make up for the skills your child lost? Now, that's one of those questions that sounds a little bit like it's focused on lost skills, but it's not for the purposes of deciding whether or not there was entitlement to the skills. It's really just figuring out how much. We know that there has been a loss, and now we're trying to decide how to make up for the lost education. Now, some children might need more than one-for-one services because of the regression they've sustained. Others might need less. And the decision in the qualitative approaches is really an individualized and based on child's needs and on information and data. Now, what happens in the Ninth Circuit is that where it is clearly connected, the amount of time in a one-to-one kind of approach is clearly connected to what opportunity was lost, you can make the argument that it just has to be the same number of hours. If it's a recent loss, if it's easily quantifiable, and they were not going to change much about the way that the student gets that service delivered to them, then that's part of what the Ninth Circuit looks at. And then they overlay that and they kind of do almost like a double check on that idea by looking at that qualitative evaluation and asking those questions about the individual circumstances and the loss of opportunity. So another question, can the parent and the school district agree to provide comp ed other than an equal time ratio? Or I would say, can they provide it in ways that are not exactly how they were described in the IEP, which is really the question. And the answer is yes. Parents and school district can agree to something besides a one-to-one ratio of services not provided. One of the examples is if a student was entitled to a one-to-one aid, maybe for behavior support, for 1 hour a day during math to keep them maybe on task and focused in math, but they received no aid for 30 days, then the parents in the school district could agree to education of 15 hours of one-to-one math tutoring. So it's fewer hours, right? But the person delivering the services has higher qualifications and it's got more intensive content. It's not just helping with maintaining focus or staying on task. It's actually math instruction. So that intensive content is going to provide a boost to the learning in that amount of time. So the parents and the school can agree to that. They can also agree on other things that are related to how much opportunity has been lost and how to get that opportunity back. They can agree to extend the anticipated high school graduation date for a student that's about to graduate out of school and then out of special education. Um, to allow that student to be completely integrated in the environment of a school where it's super educationally rich, you could extend that high school graduation date. They could also agree to add services to the IEP for a specific period of time, so long as that doesn't change their least restrictive environment or their access to other things in the school district or the school environment. But they can also agree to place a student in private school or in an out-of-district placement that could provide more intensive instruction or support. I've had clients that found help in specialized reading programs, for example, that were privately paid, and the school paid it as part of a comp ed award. The example that I gave up above is this, which is to provide fewer services or less time of individualized services rather than a larger amount that were missed in small group therapies. So again, it's that small group provides less intensive focus on the needs of one student. So you can take fewer minutes or fewer hours with more direct one-to-one individual services to make up for what was lost from small group strategies. So how can compensatory services be provided? They can take many forms depending on what would be appropriate for the particular student. It can be tutoring that is overlaid on a school day. So after school tutoring, weekend tutoring, it can be summer school, or other services that are developed by the district, as well as allowing a parent to select private providers, like I mentioned with the reading program. In some cases, courts and hearing officers have awarded comp ed in the form of a trust fund for parents to use to obtain services for their child. And I'll tell you in a minute about some of the circumstances that might give rise to that. In other cases, courts have found that a private placement is an appropriate form of comp ed. You'll see that when the needs are very intensive or highly specialized, something that an ordinary school or a small school district can't really provide. And so a private placement would be a way to provide relief for a student that's been denied an educational opportunity. When can compensatory education be provided? Right, we're talking about kids who are going to a full school day and a full school year. And if you've got a lot of comp ed due, which happened throughout some of the restrictions on attendance in school during the pandemic, it can be a fairly large number of hours, pretty diverse services, and sometimes expensive services. So when is this all going to happen? Well, of course, it has to be in addition to the IEP services that they get through their current IEP, because you're supposed to be providing that for them right now. They can be provided by school staff or private providers before or after school, on the weekends, during the summer, or when school is not in session. That's one of the ways that you can do that when and not impact their current IEP services. Now, comp ed can be provided during the school day, but it can't interfere with, as we've said, the special education or related services that are in the current IEP, but it also can't interfere with their participation in the least restrictive environment. Now, if you remember from our last session, least restrictive environment is not about not being able to move around. It's about proximity to non-disabled age peers. It's about inclusion, being educated as closely as is appropriate with supports and services that are needed for the student to benefit from the general ed environment, the closest relationship educationally to their non-disabled peers. So if a comp ed delivery during the school day is going to pull a student out of their general education classroom or a time that they are active with non-disabled age peers, then that's interfering with the least restrictive environment. That's secluding, increasing their isolation from age peers that are not disabled, and that violates the law. And remember that our LRE includes not just attending general education classes, but it's also participating in non-academic and extracurricular activities, meals, recess periods. We're talking about dances and games, sports. They call says PE, but I think of PE as an academic subject. So I don't know. I wrote that down, but I'm wrong. It also can't interfere with the variety of educational programs and services that are available to non-disabled children in the school environment. So we're talking about art clubs and opportunity to be in the band and things that are industrial arts, consumer and homemaking education, vocational education opportunities, including internships. So comp ed has got to be added on outside of all of the rich opportunities that are available for students, both disabled and non-disabled, in a school environment. Now, if the comp ed is provided outside the regular school day, it does have to be at a mutually agreeable time. I have seen a school district try to provide a particular service in a rigid, inflexible time format and imply that it was take it or leave it to the parents. And I think they were misunderstanding that it had to be at a mutually agreeable time. All right, now these are some quick ones about receiving comp ed services. Quick questions here. What if we move from the district? Doesn't matter. Students entitled to comp ed after they move to another district or even another state. Because obviously, well, I'll say that in a minute. What if a student ages out, right? If they turn 22 in the year and at the end of that year, they've aged out of the school in Alaska. But a student who turns actually 22 in our state years of age or is issued a diploma, they're still entitled to receive comp ed for prior FAPE violations. So you can imagine that not doing it this way, either requiring them to be in the district, in the state, or not allowing for comp ed after a student ages out would create some incentives on the part of the school district to delay and also potentially to create an environment for families and students that made them move out of school districts. So to do otherwise didn't make any sense, and the courts have said that these are not things that bar entitlement to compensatory education so long as the violations occurred before they aged out or got a diploma. And what if we don't use it? So I have had a client who was in this circumstance. They had such a large compensatory ed bank, they called it, that they were at risk of not using it all. And what happens then is you look at what's called equitable considerations. There's a fairness component to some of the delivery of comp ed. Question being asked, Why didn't it get used? Was the was the service delivery so difficult, the school inflexible about timing and place that the parent couldn't get the student to the replacement service location? Were there obstacles created by the parent? Did the parent refuse to talk with the school district about things that were not working? So those kinds of things are going to have bearing on what happens to comp ed as a student starts to approach either aging out or a move. Um, so the conduct of both parties is going to be relevant to that. And what I have seen is that the bank is extended. That was what happened with my client. We changed the terms of the how the bank could be accessed and moved to particular approved private providers in the community. And the Comp Ed award was then used for private services for reading and for vocational education and some transition to adulthood skills for increasing independence as an adult with disabilities. And that's that trust that I was talking about in one of the previous slides. What if we, family, have already paid for services to catch the student up? And I mentioned that earlier, and the court has repeatedly said that a Comp Ed award is not just prospective. It isn't just for expenses up ahead. Reimbursement is an appropriate remedy if it was the right choice for getting relief for a lost opportunity of education. All right, some of the other questions we've heard. These are a little more in response to claims being made, and they are what you see when you look at the due process hearings decisions and the state complaint investigation reports across the country now. So I pulled those together from another source. The district says that students with disabilities are not entitled to any comp ed because all students experienced some learning loss during the pandemic. This is one that came up in one of the state court appeals. So it was a decision. The district says it didn't need to provide all IEP services because I chose full-time remote learning for my child rather than in-person instruction. And another one was the district says compensatory education says that they shouldn't get compensatory education because the parents did not provide sufficient support for their child to learn virtually, right? Parents having to help a student with learning by online platforms and not helping sufficiently. So I put all these questions together because they all have the same answer. You might have guessed by now because we've said it a lot. But during COVID, school districts remain responsible for ensuring that students with disabilities IEPs are fully and appropriately implemented and for providing comp ed when that does not occur. That's a direct statement from the U.S. Department of Education's guidance on COVID-19 restrictions and impacts on learning for special education. Other questions we've heard continued. The district says it doesn't have to provide any comp ed because I did not complain about the services provided during the pandemic. It's a well-established statement of law long before COVID that a child's entitlement to special education should not depend upon the vigilance of the parents. Rather, it is the responsibility of child's teachers, therapists, and administrators to ascertain the child's educational needs, to respond to deficiencies, and place him or her accordingly. So this is that statement that while parents are an important part of developing an IEP and reviewing progress notes and suggesting changes to the IEP and requesting assessments for things that they see that parents would see and that the school hasn't responded to, all those things are very important. Parents have a big role in the IEP process and as a safeguard of implementation. But people who are really responsible for providing services and making sure those services conform with the IEP, those are the school-based faculty, staff, and most importantly, the school district. Another one, district says the students with disabilities don't need comp ed because they set up these remedial programs for all students, right? These services that were going to speed up education to make up for the time that all students lost. And that was it's great that school districts were providing those, and especially with regard to creating positive behavior interventions and supports across entire schools and creating drop-in for tutoring for math and providing the availability of school counselors and psychologists for some of the trauma associated with being part of a worldwide pandemic. All of those things are great. They can't substitute for IEP services. So recovery services that they were, excuse me, that districts provide generally to all students aren't a substitute for comp ed, and that the district has to use a process that exists under the IDEA already for making individualized determinations about services based on each child's unique needs and circumstances. What if the district says that COVID-19 was a health disaster and they were only required to provide services to the maximum or greatest extent possible, and that's a reason that they aren't going to provide comp ed? Another thing that we've heard is that the funding for the Recovery Act was only for 2 years, and that Recovery Act money is all gone because of recovery services. And so there are no more resources for making a claim for comp ed. And to both of those things, I would say no, because there were no waivers of the IDEA or Section 504 requirements. In 2020, Congress asked the U.S. Secretary of Education to testify and recommend whether states should get temporary waivers for helping them deal with the lack of special education and services to other disabled students. And the Secretary told Congress that it was not requesting waiver authority to any of the tenets of the IDEA or Section 504 of the Rehabilitation Act. And most notably, the Secretary of Education stressed that the free, appropriate public education in the least restrictive environment was not something that they were going to request waiver authority for. So they weren't going to allow states to waive that requirement for FAPE in the LRE. And the Secretary said it was because the IDEA has mechanisms internally for providing compensatory education for missed educational opportunities in the IEP. Lots of times the district couldn't get needed computers or other devices or fast enough internet speeds needed to access virtual instruction. So what happens then if the district just couldn't do it. Well, they have to provide equally effective alternate access to the curriculum or services provided by other students, first of all. And secondly, also packets with parent assistance was not considered equally effective alternative access. I'm sure some of you dealt with some of those packets as parents. Um, and if the district couldn't get a device to a student and then replaced that with some sort of paper packet that the parent was supposed to walk the student through, and other students had computers or devices, then that was not considered equally effective access. But the real sort of fix for this is after the pandemic, the IEP team had to review and decide whether comp ed was due for a material denial of FAPE. So that's again, it's always the same. If there is a material gap in services, then there is entitlement to comp ed, and comp ed has to be decided by an IEP team and remedied. If the district just says it acted in good faith, it tried its best, and now it can't do, it has no resources. There are short-staffed. They don't have enough access to related service specialists in their region, or they don't have the money. Are they still provided to provide comp ed? And the US Department of Ed roadmap to the return to schools made the statement that many school districts made significant efforts during the extended school closures to implement IEPs. But an award of comp ed does not require finding bad faith or fault on the part of the school district. Lots of educators and administrators were working so hard to provide education, to keep their students safe, to keep their own families safe and themselves from getting ill. It is not about bad faith. It's not about fault. The IDEA just says that this is what is needed for students with disabilities to achieve, to get benefit from their education. They had to have an IEP that gave specialized instruction and modified curriculum and qualified educators in environments that were designed for them to succeed. And those things need to happen, or the school district needs to make up for the lack of those things happening, unrelated to whether there was bad faith. So now we're going to talk about the key federal laws that protect the educational rights of children with disabilities. You probably know them and you've heard them often enough. There are three primaries. One, of course, is the Individuals with Disabilities Education Act, and it provides for special education for children with disabilities who require individualizations of programs and also early intervention for those under 3 years old. And I just summarized what that specialized education contains in my previous slide. Section 504 of the Rehabilitation Act also applies, and it doesn't just apply for kids who have a Section 504 plan. It also applies to kids with IEPs when you're talking about particular things that are not related directly to their IEP, but are based on disability discrimination. A quick example is having students with intensive needs wearing an orange vest on the playground at recess so that their specific playground aide could spot them easily when they were mixing in with the rest of the school population. To keep them safe and to keep an eye on them, a school decided that that would be a good idea. That was actually an example from my practice. And it just took a single phone call to say that that violated Section 504 of the Rehab Act and the ADA. Section 504 is a civil rights equal access law. and it applies to any program receiving federal funds. So equal access to participation in school, after school, childcare, extracurricular activities, and also to be free from discrimination based on disability that isn't related to their IEP. Americans with Disabilities Act is very similar to Section 504. Um, they get quoted together just in case there's anything that applies in the ADA that isn't available under Section 504, which is a kind of a more limited law. But it is a civil rights and equal access law, and it applies to places of public accommodation and some other things. It provides for equal access to participation in school, after school, childcare, and extracurriculars as well. There are some ways in which one or the other will apply in unique circumstances, like when you're dealing with private schools that are in a religious setting. Some of those differences will apply whether you're using Section 504 or the ADA. Now, some ideas for dispute resolution. You can find some more suggestions online as well. Lots and lots of parent information centers like Rights Law or Parent Hub. Pacer is another one. They have great lists for how to move from a kind of a low conflict dispute resolution through the higher levels of conflict, and some tips about how to handle a meeting, how to use the time during a meeting to create good relationships with the educators around the table. There are some really great lists like that. And I suggest to you that it might be helpful to wander around through those pages, through those websites. It's also very important to talk with other parents, to have an opportunity to debrief, to honestly complain if you need to, and to celebrate when things work well. Having a parent group that you're part of, I think, is a very important thing. And I know in our state, Stone Soup Group is a really great place to find those groups, mentoring and support. So if you want to go check their website out for that. But at the school level or district level, one of the things that you can do is honestly just talk. Talking with a classroom teacher, the general ed or special education teacher, and the IEP team is a useful thing. But anything that you want to make sure that you keep track of, and that you can show to other people that you've kept track of, is to put things in writing. And one of the great ways to deal with a dispute at a lower level of conflict is just to request a meeting in writing. You are concerned about implementation during the pandemic. You realize that there were things that were missed. You want to make sure that the team is not just looking ahead at the changes to the current IEP, but is also looking back to see if there were gaps in opportunity to learn. That may give rise to a need to an assessment or a reassessment. Maybe it takes the form of classroom observations. Maybe you could ask for work samples to be sent home. Compiling a weekly list of quizzes that you would want to see. Maybe you want to have a weekly math quiz sent home. That's an easy thing to request. And what it does is allow you to look over week to week. Trust me, you're not going to look at it on Saturday, but maybe at the end of the weekend when everybody's kind of tired out and you're looking at your email, you can go in and open up that work sample and see what it looks like compared to last week's or the 3 weeks ago. But those kinds of things, you can ask for a teacher to send you work samples home. You can request an assessment to, to confirm whether or not something you think is happening is happening. Now you can request an independent educational evaluation, and we've talked about that in a previous session. That's when you disagree with an assessment that's been done by the school staff or under the school's authority. And you want to have someone outside of the school do an evaluation. And the way to do that is to say that you don't agree and request the IEE and ask for a prior written notice on the decision. And there's more information about how to do these things specifically in some of the links that I provide at the end of this session. You can also just write a letter of disagreement. That can be a very useful thing. Later on, it can be because it establishes a point where you are no longer agreeing, and it can be relevant for what's called a stay put, which is not really going to be something you're concerned with in this low level of dispute resolution, but might be helpful later on. But if you have what you suspect is a need for more or different or better services that's caused by a gap in educational opportunity from the COVID pandemic, one of the things that I want to stress is that it's often the parent who notices first. So if they are disputing your perspective, the classroom teacher or the special education teacher, even the whole IEP team, it could be that they just don't see it yet. And when that's the case, to approach it with the perspective that they just don't have the data that they need and look backward at what kinds of things you haven't done a current reassessment of, that you don't know the current baseline. You haven't gotten a recent observation. It's often about making sure that you are demonstrating the need in a way that professionals who deal with data all the time are expecting to see it demonstrated. And while that's not really your obligation, like we mentioned before, to provide those appropriate assessments, if you are seeing something, ask that it be evaluated. Describe what you're seeing, describe what you think might have caused it during the pandemic, and then request that an appropriate evaluation to address that suspected area of need be provided. And of course, do it in writing. And I'll show you some places where you can find what those look like in a minute. Now, at the state level, what you end up doing is, and you make this request to your school district, but the state provides it. You can make a request for a mediation or facilitated IEP meeting. And those are provided by the Department of Education and Early Development. And it is an independent mediator, an independent facilitator that then is kind of the outside moderator for what happens in that IEP meeting. Now that's kind of one level up from doing these requests directly to the IEP team on your own in writing. Another thing is, of course, a state complaint. Now, for a state complaint, you don't need to be a parent. It is basically the citizen's right to complain that there has been a state agency that has not provided services or has not followed their own policies, has not followed rules internally or statutes that govern them. And it isn't just a state entity, it's also school districts. So you're basically asking the State Department of Education and Early Development to do an investigation of a school district by saying that they have not followed the laws and rules that govern how they do business. It's also really a good way of addressing a problem that you think your student experienced, but that you also recognize is happening throughout the school. A request for due process has to be parent, guardian, or surrogate decision maker started. And while the state complaints are available online, it's a form that you can fill in. And lawyers do make the state complaints much more like a kind of a court document, but they don't have to be. And you, as a state complaint filer, you would get a call from an investigator. The investigator would talk to you about what you were claiming, and then they would talk to the school or the school district, and then they would come back and tell you they're saying such and such. How do you answer their defense of your complaint? So it's an investigation, is that state complaint. The due process hearing is much more like a litigation. It's a hearing, and there are rules of evidence, but they're sort of loose rules of evidence. They have briefs that get written and filed. People are talking about standards for making claims. And even though Congress never intended it to be this way, it has become much more like a little trial. So access to legal representation is an issue. It's important probably for the due process hearing. Now, at the federal level, the federal government has a responsibility for states making sure that students in that state who are disabled have access to special education under the IDEA. So the federal government has authority, and the way that it shows up is either when there are appeals from state level decisions, they will go to the federal district court, or through the Office of Civil Rights in the US Department of Education. You can file a complaint there that is similar to the state complaint, and it's a similar process. You would get called by an investigator who would ask questions about the circumstances that gave rise to your civil rights complaint. The Office of Civil Rights also keeps track of and reports on their decisions, and also has statewide reports about special education delivery throughout Alaska. It's a great place to get information besides being able to make a complaint. Some things to remember. Everything in writing. That doesn't mean that it needs to sound like a threat. If it's in writing, it's there in the words that you are using, whether the tone is confrontational or is worded simply as a request. So I would suggest that you have somebody else read it after you've written it, so that you can make sure that it doesn't sound like a threat. Because threats are something that you want to use sparingly, and you want to make sure you follow up on. Save everything that is given to you in writing. Now, if you are somebody who gets who uses electronic files and is good at moving emails into folders, then do that. But you're not going to want to have to search for something 2 years old in your email that was an attachment. So if you are not the person who moves things into folders, I would suggest printing every formal document or letter that comes from your school or school district about the IEP and just dropping it in a file drawer. If you don't have a file drawer, keep a handy box in, whatever storage closet you have for your paperwork, and just throw it in on top. It may be that you want to flip through those things and use them later, or you want to provide them to a legal representative if unfortunately you have to go that far. Ask for paper copies, print them out yourself. If you ask for paper copies, they will have to give them to you. So do that if you need paper and you don't have access to a printer. Don't torch and burn relationships. Obviously, I want you to advocate diligently and with passion for your student. But keep in mind that your kid has to go to that school every day, and they will have to do that for a while, maybe, depending on how old they are. And teachers are human, and they will try not to allow conflict and what they feel are judgments about what they're doing to impact how they regard the students. They're going to, um, even in small ways, I think. So you just don't want to make unnecessary difficulties for relationships that are already taxed by the lack of resources in schools and sometimes the difficulties of providing good education for kids who have individualized needs for special instruction. You can keep the disagreement about what's being proposed or not implemented or being said or not said and not assessed. You can still have the disagreement, but make it about the the area of actual conflict, which is the delivery of that service or the failure to evaluate. And I just want to stress that if you can escalate emotion, de-escalate emotionally, then it allows you to escalate in other ways without impacting your kids so much in their environment. When you go to the Alaska Department of Education and Early Development and look for copies of due process hearing decisions and state complaint corrective action letters, you can get them. Most states have a link where you can actually pull them up and have a click on the ones that you need. You can even do searches within them. In Alaska, this is the paragraph that's there. So decisions on state complaints and due process hearings, to request copies of the records, call or send a detailed message to or fax, and the department will respond. So I did this a year ago or so and requested 2 consecutive years because I was interested in how things were happening with COVID complaints and due process hearings. And that's exactly what happened. I got an email within 3 days. And the first one said, we are compiling your list. And the second one came, I think, a day later. And it had all of the decisions that I'd asked for 2 years in a single email. I could access it was, I think I was able to use them. I couldn't search through, so I had to read each link, but they were links. So I use those because as a lawyer, it helps me see what's going on across the state and whether people are making use of these opportunities for getting comp ed. But I also look at them to see how people are describing what has happened to them and what the due process hearing decisions are saying about whether or not that gives rise to a comp ed award. You can use them that way too. You can actually use them for gathering language. If you decide that you like the way a parent has described something on a state complaint form and it matches what happened to you or your student, then you can use that language. There's no plagiarism to borrow from another parent's state complaint. A parent's resource guide. So this resource guide is on the Department of Education and Early Development's website, and it's a pretty good statement of the law, and they have some other resources there too. Also, the Stone Soup Group has a special education handbook. Parent Center Hub. This, I really like their resource library. Besides being very extensive and having lots and lots of topic areas where they give you more information about different kinds of services and implementation and advocacy as a parent, they also have a really nice section. Okay, that's the second link. Sorry. The second link on the Parent Center Hub is Their letter library. They have sample letters for requesting evaluations, for requesting reevaluation, for a disagreement letter, for um, an independent educational evaluation, those kinds of things all through there, and explanations about how to write them, when to write them, and why. And the last is the OCR Case Bank. So that's the Office of Civil Rights in the U.S. Department of Education. And they have a case bank that allows you to look, first of all, by state. So you can go in and look at the OCR complaints that have been made and investigated in Alaska, which is a handy thing to do. And it also gives you case banks from other states so that you can look at what kinds of circumstances have been found to entitle students to a Comp Ed award. So it's a really great way to compare through other people's stories, basically, and what the investigator reports say about what happened to those students during the COVID impacts. So I find these stories very helpful. And they have more about their investigations in this next link as well. Lots of resources at OCR and at the Parent Center Hub. Resources for getting advice and assistance. What I did previously was give you places that we're going to give you examples. Now, this is more about the letter writing and samples from the Parent Center Hub. This is the link for that. And what you would want to do if you couldn't use this link specifically is to go Google Parent Center Hub and sample letter or letter writing, and it would pull up their list. So what I wanted to give you also was opportunities for larger kind of background learning, like Wright's Law. Wright's Law had a long history of providing information for parents as advocates and for translating law and rights into action for parents. Their website had gotten a little bit, how to say, not current. And in 2023, they redid the whole big thing. And they took out references to the 1997 amendments to the IDEA, and they updated their blog entries and took out some things that no longer applied. And so it's really become, once again, very, very useful. Honestly, they also come and do trainings. I think last year, Stone Soup Group brought Wright's Law for the parent conference, and I think they're pretty committed to doing that every other year or every third year. And if you can get to one of those, do. Here's a great file on how to file the OCR complaint. So this is just advice. The Disability Law Center, people have had difficulty getting help from the Disability Law Center in the last couple of years. I think people have a better success if they use the online contact form than if you just call. But you have to keep in mind that the DLC has been flat funded for close to a decade. And with increasing need and increasing expense and flat federal funding, the priority list for Disability Law Center services has really focused on just the top two biggest, worst things that can happen for students. They don't have as many lawyers working, and they don't have as many non-lawyer advocates working in special education. They've had to close down an office and have more work done out of their main office. And that's all because federal funding has not increased. And while there is access to paid lawyers, the free lawyers that everybody has come to expect in this area of law are fewer. And so right now, Disability Law Center is focusing their limited availability on students who have been denied access to education entirely, kids who are not in school, and also kids who have been wrongly denied eligibility for special education. Those are the two categories that take up all of their effort in our state. So it is a civics problem if people don't want to pay federal taxes to support free legal services for enforcing special education law, then we end up with limited access to needed legal services support for those students. But try it. Northern Justice Project has been taking some cases as well. They are also sort of the other free lawyer option. They seem to spend more time on their larger sort of class actions. They just had some just this last winter that they've started, and they may well be helping in other ways that I'm just not aware of. And of course, you can get information for self-help from Stone Soup Group. They have parent navigators and also special education navigators that are available regionally. So you can call them and get some help if you need navigation through IEP meetings and looking for referrals for other kinds of help. And Links in Matsu also does something similar to Stone Soup Group for particularly focusing on Matsu region. Well, that's the end of the 5-part series. I hope that you get a chance to listen to the others or watch the others, because there is much more detail in all the different areas of topics that we covered. And I want to thank you and thank Stone Soup Group and, of course, the Alaska Mental Health Trust Authority, and wish you all well.